Juries. Oh, good. We just recorded it. Perfect. Didn't forget that. I'm Debbie Gross. I'm the CEO of Pennsylvanians for Modern Courts. PMC is devoting this year to focus on jury service, as it is so important in so many different ways. One, to educating people about our democracy; two, providing civics education; and three, providing an opportunity for justice to be served. We had our first program with Nancy Martyr talking about just jury service. We are really excited to have today Emily Coward, who is the director of the Inclusive Juries Project within the Center for Criminal Justice and Professional Responsibility at Duke University School of Law. Emily has been focusing on jury composition, I'm going to say, for many years. She really has published a lot. The North Carolina I'm sorry, Inclusive Juries Project is an interesting project. North Carolina has only recently, I'll say, taken or had some decisions. The North Carolina Supreme Court has only recently had some decisions interpreting the Supreme Court's ruling in Batson, which has to do with challenges to jurors serving and making sure that we have a diverse and fair jury. Prior to that, Emily was at the School of Government of Duke as part of the Public Defense Education Group. She helped establish some bench books or bench guidelines for judges. She provided a number of trainings, and she is for lawyers and judges, and she's a national expert in addressing efforts to address racial disparities. She's been asked to testify. She's written reports. For those of you attending for CLE purposes, after the program, we will be sending around information that Emily has published during the program. So first, we may have a trouble getting a CLE credit. We are not sure, but I am going to, we are getting the CLE credit from Morgan Lewis. And again, there's been some technical difficulties with this process, not due to Morgan Lewis's part, but due to PMC's part. But I'm going to say a code in the middle of the program, Emily. So I'm going to interrupt at some point so that if you're here for CLE, please write down the code. We'll be sending out the forms after the program with the reading materials. So I want to say, Emily, thank you for joining us. What we hope is that the participants will feel free to put questions in the, I don't know if you can put it in the chat, or I think it's in the Q&A, and I will in the Q&A, and I will then share them with Emily after her initial presentation. So Emily, thank you so very much for joining us. We are really excited to have you.
Thank you so much, Debbie. And thank you, Michelle, as well, for all your work putting together this excellent series. I'm honored to be a part of it and really pleased to be with you tonight. Everyone can hear me okay? I assume someone would let me know if you couldn't. And I just want to say, in addition to putting things in the Q&A, if you put anything in the chat or the Q&A, Debbie, please feel free to interrupt me if there is a question that's like clarification or something that someone would like to add to what I'm saying. I'm sure that the knowledge base in this group is vast, and I'm here to share, but also to learn. So I really invite you to join in. And once I start sharing my PowerPoint, I won't be able to see if there's anything in the chat or the Q&A. So I really want to encourage you, Debbie, Michelle, anyone else to jump in if there's a question or a comment that goes to what we're discussing. So I want to thank you for carving out time from 5 to 6:30 on a weeknight in this chaotic time of year to talk about this important subject. I don't know what it's like in Pennsylvania right now, but I'm joining you from Durham, North Carolina, where tomorrow is the last day of school for Durham Public Schools. So teachers are rejoicing, parents are scrambling, kids are bouncing off the walls, or maybe that's just my house, I don't know. But it's a chaotic time, and for you to have decided that you want to join a 90-minute discussion of inclusive juries is just, I commend you for that. And I'm so glad that you're here. In a minute, I'm going to start sharing my PowerPoint. So again, interrupt me, please, Debbie, if there's anything that you can't see or if any part of it is not working. I have been cursed with a lot of technical difficulties today, so don't want to assume anything. But again, thank you for doing this series. Thanks for all that you're doing in Pennsylvania to pursue best practices around achieving representative juries and for bringing me into the conversation. I'm going to start sharing my screen here.
You should be able to, because I shared the capabilities. Okay,
It
yes, we can.
appears that I can. I actually am going to stop and make sure that I did it in the way that's going to allow the couple audio and visual. There we go. It is not allowing me to optimize for video and sound, so that may end up being just a slide that I'll need to skip, which is
Let me see.
fine.
Maybe there's an advance multiple panelists. That's all. That's all the Zoom has here. It says multiple panelists can share, so it must be on your.
Yeah, there's two boxes for sharing sound and optimizing video that I can usually select, but they're not letting me select right now. So I don't know where I would go to fix that, but I'm just gonna say that I'll give that a skip for today. Okay, just go ahead and share this. And
You have to
start from the beginning.
Okay, and it says double click for full screen, so I don't know if that's a full screen or not. Okay,
Are you
perfect.
seeing anything around the edges?
No, now it's good.
Okay,
Perfect.
great. This is the full screen. I think this is what it's going to be. So again, thanks for joining me. I'm here to talk to you about the many factors that go into ensuring that our juries are truly representative and inclusive and compliant with the constitutional requirement of a jury selected from a fair cross-section of your peers, a jury that is selected without discriminatory intent, and kind of talk about how we got to where we are today, what sort of reforms are on the horizon, and what are sort of the big things to know about this topic and how you can play a part in kind of improving the landscape around jury inclusivity in Pennsylvania or wherever it is that you practice. So I'm going to start out with a roadmap that shares a bit about what I hope to cover tonight. We might not get to all of it, and that's okay. I definitely want to stop before we reach 6:30 so that we have plenty of time, 20 or 30 minutes for Q&A. So if there's parts that we need to skip, that's totally fine. I'm just going to give you this PowerPoint when we're done so you can go back and look at it and look at the materials that are referenced in the PowerPoint in case we don't reach all of the kind of subtopics tonight. So I want to start by introducing myself a little bit more and telling you how I came to this topic and sort of my vantage point on it. Then I want to give an overview of the factors that I see that influence whether or not a seated jury, and before that, a jury pool, is truly inclusive of the community. I want to talk a bit about the historical setting here, how we got to where we are in this arena where we have a long-standing practice of juries that are not composed of the full community, but often, and I would say usually, underrepresent people of color in this country. I'm going to talk briefly about the fair cross-section guarantee and spend more of my time talking about Batson and kind of the reforms that we've seen in states that have decided to replace the Batson standard with something that has a bit more teeth. And I'm going to back up and make sure that we kind of have a framework for understanding why it's so important that our juries represent a fair cross-section of the community, and the studies that have looked into the influence of jury composition on jury outcomes and on public perceptions of the jury system and the justice system as a whole. I'm going to speak a little bit about the problems with Batson, which are very well known and documented, so I won't belabor them, but kind of talk about how the court has developed the Batson framework since it was decided almost 40 years ago, the case of Batson versus Kentucky in 1986. And then I'm going to kind of talk about the tools that I have worked on developing that are for specific court actors in addressing bias and how bias may play a role in distorting how our juries are composed and how juries do their jobs. And then I'm going to end with some recommendations, both in terms of for practitioners and for policy reform for achieving inclusive juries. Debbie already introduced me. Thank you for that very generous introduction, Debbie. I just wanted to share a bit more about what it is that I do here at Duke Law School. I lead a project called the Inclusive Juries Project here that was founded in 2022. And primarily I work on policy reform, research, and teaching related to inclusive juries. I led up the work on that topic for the North Carolina Governor's Task Force for Racial Equity and Criminal Justice. That task force concluded its work in 2024, in December of 2024, a few months ago. But our new governor, who was sworn into office in January of this year, was one of the co-chairs of the task force. So the projects that were created as part of that task force are very much still alive and well and have the support of the governor's office. So many of the jury issues that I worked on and jury projects are still moving forward with kind of a loose group of task force members kind of shepherding them forward. And I often conduct Batson and fair cross-section trainings with Duke Law students. We've developed a new seminar, Juries, Race, and Citizenship here in Duke Law that we debuted in the fall that I'm very excited about. Might be able to talk a little bit about tonight with public defenders, private defense attorneys, appellate judges, and prosecutors. And this really all came out of my work on a manual on litigating issues of race, and then the interest that I received from practitioners in getting more specific and drilling down on how to litigate Batson, how to preserve Batson issues, questions from judges about how to rule on how to kind of weigh Batson evidence. And so that became kind of an area of specialty to for me, following the publication of this manual that was really looking at how race may play an improper role in criminal justice outcomes throughout the criminal process. So I want to ask, if I may, if you don't have to turn on your camera. I think we're not set up that way tonight. But if you could put in the chat or in the Q&A at the outset of this, if any of you have any specific questions about what you're hoping to learn about juries, jury formation or jury discrimination tonight, or if you are someone who plays a role in selecting juries in Pennsylvania, if there's one thing that you could change about how juries are selected in Pennsylvania, what would it be? So I'll pause for a moment to see if anyone has any responses to those questions. And then I'll keep it going with the rest of the presentation.
I don't see anything yet.
Okay. Well, this isn't the only moment that you will have an opportunity to weigh in. So if something crosses your mind that you're hoping that we will address tonight, I'd love to hear what's on your mind, what you're curious about, what brought you here tonight. in addition to the CLE credit. And I have presented on racial equity and jury formation in the Philadelphia District Attorney's Office in partnership with Professor Cami Chavis from William and Mary at the Delaware County District Attorney's Office. And so I've had the occasion to learn a little bit about how jury selection works in Pennsylvania, but I'd love to hear what you're working on, what you're struggling with, and what's on your mind. So don't be shy about putting something in the chat or the Q&A if there's a specific subtopic that you'd like me to address. Okay, and then I also want, I'm not sure if I have you with me for this. I'm kind of used to doing Zoom where I can see the participants. But even if this ends up just being a kind of one-sided exchange here, I'm just gonna walk you through an exercise where you close your eyes, or you're invited to, or not, your choice. Imagine you've been charged with a crime. And it can be whatever just kind of auto-populates in your mind when you hear that you're charged with a crime. Whatever that crime was, that's the charge you're facing. You have a lawyer and you go to court and you've decided you're going to plead not guilty, and you're going to exercise your Sixth Amendment right to have your case resolved by a jury of your peers. So this is really intended to just focus our minds on what's at stake for folks when they decide to go to trial and to exercise their Sixth Amendment right to have their charges resolved by a jury. So what would you need to see? What would give you confidence when you looked out at how jury selection was playing out, that your jury would be fair and would be fairly deciding your case? I want you to think about that. Again, if you have something that comes to mind immediately that you'd like to share, go ahead and do so. But if not, just hold it in your mind and keep it with you as you think about all of the different ways in which we struggle in this country to actually form juries that adhere to all the constitutional requirements, and how significant the stakes are when we get this wrong. Some of these tools were developed in classes that I do where we're sitting in a circle looking at each other. There's a lot of eye contact and kind of community building. So some of them translate to Zoom better than others. But I still invite you to just sort of take this in and imagine that you are in the position of someone who's going to be facing the decision of a jury that's going to decide questions related to your liberty or lack thereof, perhaps life or death. And just, keep in mind what's at stake when we talk through these issues. So one of the reasons that I'm glad to be with you today is that any attention paid to our jury system right now is critical and very necessary, because our jury system, I think at this point, is on life support. It is a vanishing right, even though it is this crucial bedrock foundational right in our Constitution from which the legitimacy of our criminal justice system derives. It's sort of how we have the voice of the people come into matters of justice in this democracy. Only a very small portion of cases are disposed of by jury trial, as you probably know. This is from a National Center for State Courts publication from 2023, concluding that about 2% of felony cases and misdemeanor cases. Sorry, some of my screen is blocked by the video, so I think I'm getting that right. And less than 1% of civil cases are decided by jury trial. So we are fewer and fewer of our cases are being resolved in this way. And you can see here the estimated number of jury trials in state courts over the past almost 20 years. Already in 2007, a very small portion of cases were resolved by juries, and that number has been shrinking. That decline was accelerated by the pandemic, but not entirely caused by it, and we haven't quite bounced back.
I'm gonna, if you don't mind, I just want to give people perspective. So 148,000 is how many cases can be filed in Pennsylvania in a year. So, you know, when Emily's showing these numbers decreasing, right? The concern is that there's a, we all think we can have a jury trial in, that will help us, right? Protect us. But as these numbers show, there's a significant number of decreasing jury trials that are occurring, and I'm hoping you'll explain why. Sort of, or maybe,
Well, it is,
or do you have some
it is,
hypothesis?
I appreciate you jumping in and pointing that out. And I don't think that we have a court system right now that's set up to actually resolve many more cases by jury trial than we currently do. When you think about the waiting times that people have in North Carolina, you see people sometimes waiting 4 to 5 years for their jury trial if they choose to proceed to a jury trial. I think there's a complex mix of factors that you won't be surprised to hear, and I'm not going to spend a lot of time in tonight's presentation diagnosing how we got here in terms of that decline, but I will refer you to the National Center for State Courts recent publications on this topic that I think do a really nice job of kind of digging into all of those overlapping issues, one of which is the trial tax. But another one is, I think, the hesitancy that defendants rightly have in feeling confident that they're going to face a jury of their peers and that they can trust the jury system. So we're going to kind of be talking about that element of it tonight. I certainly don't mean to imply that that is the primary reason for the decline, but it is one factor that I think is in the mix here for sure. Backing up and looking at the kind of whole jury formation system, I want to just name at the outset what I see as some of the main factors that are influencing the question of how representative and inclusive our jury pools and then our seated juries actually are. So we're kind of switching gears from talking about the number of jury trials to who ends up serving, and do we have access, or do we still have many barriers for folks that are called to serve as jurors? Obviously, financial and logistical barriers to service are an enormous impediment to achieving inclusive juries. I know that the issue of trying to raise juror pay is one that you in Pennsylvania have looked at for a while, and there's reform happening across the country and trying to increase juror pay, but it's not keeping pace, even close to keeping pace with the inflation and the cost of living. And we'll get a little bit deeper into that further on into tonight's presentation. But the barriers that we're all familiar with: transportation, child care, elder care, wage workers who are going to potentially not be paid or compensated at all for the time that they're serving as jurors. There's a number of barriers to jury service in Pennsylvania and in this country as a whole that influence who ends up not being able to serve. We also suffer in this country from a lack of accessible, transparent jury data that allows us to monitor whether or not we do capture a fair cross-section of the community in our jury pools. Some places like Pennsylvania collect jury demographic data on forms, but it's not accessible to members of the public. It's not always available on appeal. So that is a major problem. Professor Liz Simmel from Berkeley Law recently wrote a report called Guess Who's Coming to Jury Duty that you can find on the Berkeley Law website, that documents across the country this real massive problem of the failure to collect jury data and how that really causes problems for ensuring that we are bringing the full community into the right to serve as jurors.
And in Pennsylvania, it's not it's not a requirement set forth by the Supreme Court, which runs the AOPC. So every county does it differently.
In terms of the demographic data collection?
Yes.
Right. So you have a state form, but it's not mandated that it's used at all courts. Okay. Yeah, that's problematic for reasons that are I think you probably don't need me to identify. And then we have continuing this problem of the disproportionate exclusion of jurors of color at each stage of the jury formation process, the creation of jury pools. In Pennsylvania, for the counties, it sounds like most of the counties are using the statewide jury pool, which pulls from, as I understand it, a larger number of source lists than some states, like in North Carolina, where we only use drivers and voters. But that still is can be a source of exclusion for sure, is at that first step of the creation of juror pools. The qualification of jurors, removal of jurors for cause, peremptory strikes. I'm kind of going quickly through these because I'll get into them later on in the presentation. But if you think of jury formation as a funnel where you start with a big list of names, and then at each stage you kind of whittle down to a smaller list. At each stage, in all of the studies that have looked at this, the disparate overrepresentation of white community members and underrepresentation of communities of members of people of color in the community are, the problem is exacerbated at each step of the jury formation process. And bias can also creep in at all of these stages, as I will discuss later on in the tonight's presentation. I want to recognize that I think there are a lot of groups in Pennsylvania that are working at on implementing some best practices and trying to improve the ability of Pennsylvania courts to seat inclusive juries, including the Interbranch Commission for Gender, Racial, and Ethnic Fairness. The statewide jury list appears to pull names from a more diverse range of sources than we see in some states, including the state where I am currently based. You have annual updates to the jury list. We only do it every 2 years here in North Carolina. Some states like New York do it every 6 weeks. And this is what I'm talking about, is how frequently do you refresh the list of names to keep it current? The longer you wait to refresh your list, the more stale the list gets, and the more it underrepresents low income individuals who are more likely to be transient and move more frequently. So updating the list frequently is a best practice for achieving inclusive juries. It appears, although Debbie, I appreciate you giving me more details about this, that the collection of juror demographic data is not uniform, although there is a state form that is available, but it's not mandated. So, and from what I could tell, it looks like it's not possible for members of the public and folks that are doing post-conviction litigation and that sort of thing to access that data post-voir dire anyway. Correct me if I'm wrong about that.
So you can reach out to jury commissioners on an individual basis.
Okay.
And some are willing to share and others are not.
Okay. Yes, somewhat inconsistent. And I'm familiar with that. That's also the case in North Carolina, that things are very county by county and commissioner by commissioner.
That also has to do with like the resources. Allegheny County and Philadelphia County have more resources. They have jury commissioners, and other, Philly has 67 counties and they don't have as many resources.
Sure. Yeah, that's very similar. In North Carolina, Mecklenburg County, where Charlotte is, has this long-standing childcare program in their courthouse for jurors, but that's because Mecklenburg has more resources than North Carolina has 100 counties. And so we have a lot of variance across the state, as you might imagine.
And we have that same thing. Allegheny County has something for childcare. Philadelphia County doesn't, yes, right.
Yeah. I also just appreciated seeing, as I was doing some research into the kind of landscape in Pennsylvania, that there's some new tools for addressing juror mental health, which has been a really neglected topic. I think over the years, jurors are exposed to some very traumatic content oftentimes when they come and serve, and then they're just sent back off to their lives without a lot of support. So I appreciate that this work is taking place in Pennsylvania, along with supporting jurors who speak English as a second language, ensuring access for those jurors as well. Rule changes around requiring transcription of voir dire. This seems to have taken effect earlier in 2025. So there's work being done, I can see, and also there's jury practices everywhere, including in Pennsylvania, that are in need of attention and reform. And the ones that jump out at me are the lifetime bans on jury service for people convicted of felonies and certain misdemeanors. I believe Pennsylvania has the dubious distinction of being one of only 3 states where people can be excluded from jury service for life for committing certain misdemeanors.
Yep.
And I know there's been efforts to address that, but as far as I know, they have not yet succeeded.
Not yet.
And then obviously this issue of demographic data, which I already talked about, Batson reform, which we're seeing in some states, and maybe there's some discussion of in Pennsylvania, I can't quite tell, but I'll be talking more about that tonight. And low juror pay. So in the Center for State Courts juror data dashboard, they report, and I think this is somewhat recent data, this is from, I think, 2023, that the overall daily per capita income, which is an average of a lot of different places in a big state. So that do with that number what you will, but it's $144.25. And the maximum daily rate for juror service is $25. So we see there's a big difference there between, on average, what people
And
are
that's
making.
only after day 3.
Right.
Pennsylvania
Maximum daily
starts
rate
at 9, right? It starts at $9 a day.
for the first 2 days. Is that correct?
Yes. Yep.
Yeah. So we see right off the bat that that's going to be excluding a lot of people from being able to access jury service. So I'm going to kind of back up and talk a little bit about the history of how we got here and what we need to be paying attention to when we see these patterns arising, because they didn't come out of nowhere. And when I'm looking at these kinds of issues, I like to ask, what would Bryan Stevenson do? That's those initials up at the top of the page, that acronym, that's what would Bryan Stevenson do. And his report, the Equal Justice Initiative, which he founded and runs, put out a report, Illegal Racial Discrimination in Jury Selection. And they conclude that the underrepresentation and exclusion of people of color from juries has seriously undermined the credibility and reliability of the criminal justice system. And there's an urgent need to eliminate this practice. This was from their report when they put it out in 2012. They put out a new report in 2021, which I urge you to read if you haven't already. It's available on their website. And not much has changed between then and now. There have been some additional Batson cases, but in terms of the studies looking at the continuing exclusion of people of color through peremptory strikes and also removals for cause and earlier stages of the jury formation process, we're seeing a lot of the same patterns. Black people and other people of color are excluded from participating at every step of the jury selection process. And this is a problem for many reasons, one of which is that diverse juries perform better. And unconscious associations between Blackness and criminality increase the risk of wrongful convictions. When you look at exoneration databases, one of the primary contributing factors to wrongful convictions is homogenous juries, all white juries wrongly convicting usually defendants of color. So this is a historical practice, it's a continuing practice. Our former Chief Justice, Sherry Beasley, writing for the state, for the court in State versus Robinson for the North Carolina Supreme Court. This was a Racial Justice Act case that was decided about 5 years ago. Observed that the same racially oppressive beliefs that fueled segregation manifested themselves through public lynchings, the disproportionate application of the death penalty against African American defendants, and the exclusion of African Americans from juries. This is an image of the jury that acquitted the those charged with killing Emmett Till. And so when we think about all white juries and the kind of distortion of justice system outcomes that are caused by that racial exclusion, it's both in terms of the wrongful conviction and disparate application of the death penalty when it comes to defendants of color, and also acquittals of white defendants charged with racial terror. This is just one egregious example that you're probably familiar with. There are many. I study some of these patterns historically in Durham, and the case names change, the dates change, the locations change, but often we see this pattern across not just the South, but really across the country. And what's interesting is that when we talk about jury discrimination, there's always a lot of attention paid to peremptory strikes. And those are the removals of potential jurors that lawyers can exercise, parties can exercise for no reason whatsoever. They don't have to show that a juror is disqualified. They don't have to explain their strike at all. They can just use a certain number of strikes without explanation, unless they are challenged by the opposing party who's alleging that they have violated the constitutional rights by exercising a strike on the basis of race or gender or ethnicity. But what's important to know about peremptory strikes is that they've always been about stereotypes and discrimination. They were brought over from English law, but some really interesting research conducted by April Anderson looking at peremptory challenges at the turn of the 19th century in this country demonstrates that they actually weren't used very much in this country up until there was broad immigration at the turn of the century. And then they were used not to discriminate on the basis of race, because at that point in our history, our jury pools were comprised of white property owning men. They were very exclusionary, and there were not, for the most part, with some really remarkable exceptions, there were not Black members of jury panels. It was almost unheard of. So Clarence Darrow, who you may be familiar with, is quoted as explaining in great detail in a training how stereotypes of Englishmen, Irishmen, Presbyterians, Methodist, wealthy people should be used in jury selection. And this was well known. This was well known that peremptory strikes were a tool to kind of curate your jury based on stereotypes related to ethnicity, religion, and other kind of subgroups that were determined to be better or worse depending on the party's interests. Now, when we think about peremptory strikes today, we're usually thinking about the Batson framework, which was announced by the Supreme Court in 1986. But I want to back up a little bit and talk about how the law has treated racial exclusion from jury service in the era before Batson was decided. So in 1875, Congress passed a law, the Civil Rights Act of 1875, making it a federal crime to exclude any citizen from jury service on account of their race. It has been 150 years since that law was passed. Not a single person has ever been convicted of that crime. The law was upheld by the Supreme Court in 1879. And then the next year, the Supreme Court decided Strouder versus West Virginia, where they struck down a West Virginia statute excluding Black men from jury service. Or I should say, limiting jury service in West Virginia to white men. And the court in that case, interpreting the Equal Protection Clause that had been ratified, the 14th Amendment in 1868, held that it was a violation of equal protection to exclude people from jury service on the basis of race. So at that point, those statutes that explicitly discriminated on the basis of race in the construction of a jury were adjusted, and the discrimination was accomplished through other means, just through the creation of lists that would inherently exclude anyone other than property holding white men. And so for many years, and as announced by the Supreme Court in Swain versus Alabama, if you were claiming that jury discrimination was present in your case and that, you know, your constitutional rights had been violated, you had to show a pattern of discrimination over multiple cases, many different jurors discriminated against, before the court would recognize that there had been a constitutional violation. And as you can imagine, this standard was never met. It was a crippling burden of proof, as the Batson Court held in 1986, leaving prosecutors' peremptory challenges largely immune from constitutional scrutiny. So in Batson in 1986, the court tried to turn the tide and create a new framework for allowing courts to really regulate and end this practice of jury discrimination. And so this is the part that I'm going to be disappointed if I can't get my audio working. We'll see. But let me just set up Batson for you a little bit before trying to play the audio. So this is 1984, I believe, when the case was tried in Louisville, Kentucky. James Kirkland Batson, who you see on your screen, he's the guy on the right holding his glasses. James Kirkland Batson had been prosecuted for burglaries before, and he had committed a few, but he was charged with a particular burglary that he said he didn't do. It was not him, and he wanted to go to trial. So he went to trial, and the prosecutor in the trial was James Gutman, who's pictured there holding a book. This is many years later when the two had become friends. He had been a prosecutor for about 6 months. He had tried 8 trials, lost them all. And he tried James Kirkland Batson for burglary. And there was a hung jury. And after the jury came back in, said they couldn't reach a verdict, the parties spoke to the jurors, and there was one Black woman who had served on that jury, on that hung jury. And she was the one who said, I didn't think you did it. She said that to Mr. Batson. And so the second time that he was tried, because it was a hung jury, so he could be tried again for the same charge, there were 4 potential Black jurors. And if I can get the audio to work, I'll let you hear from Mr. Batson himself about what happened next. Let's see.
As all of this is happening, I'm like, that's completely. It struck all the Blacks off the jury pool. It ain't right. I told my lawyers object to that. They,
Muted, Debbie.
Playing. Can you raise it a little bit? It is working.
He's allowed to do that.
That's as loud as it goes, unfortunately.
Do you want to start it again? Maybe I interrupted it. No. Now you're muted, Emily.
Okay, well, that's a shame. I'm sorry you can't hear the audio. If you want to go to the More Perfect website and pull up this episode, I highly recommend it. It's really fascinating to hear Mr. Batson and Mr. Gutman describe the story of this, what turned into a landmark case from their perspectives. And essentially what happened in that case was that Mr. Gutman struck all 4 Black potential jurors. And Mr. Batson was watching this happen, and he told his lawyer, object, you have to object. They're taking all the Black people off the jury. And his lawyer said, well, it's peremptory strikes. They can do whatever they want. They don't have to explain what they're doing. They can do it for any reason. There's no basis. There's no legal basis for an objection. And he said, I don't care. There's no legal basis. You're my lawyer. You work for me. Object anyway. Just make an objection. So he did. and that preserved the issue. And I think that's also when I'm talking to defense attorneys, I also like telling the story because, you know, there's a lesson in there about listening to your client and being a zealous advocate, because you may end up changing the law by preserving an issue. And so he was convicted, but then the case went all the way up to the Supreme Court, and the Supreme Court said this Swain standard that tells litigants you have no ability to seek a remedy for jury discrimination, and we're not going to even acknowledge the violation of your constitutional rights unless you can show this pattern of jury discrimination, which of course nobody has access to when they're trying a case. So the court announced a new standard, and they said, step one, if you see or you believe that discrimination is happening in the selection of a jury, you got to make a prima facie case, some evidence of discrimination. Just, you know, kind of flag the issue for the court and explain why you think that a juror or multiple jurors have been discriminated against by the opposing party. And then if the judge finds that there is a prima facie case, which is supposed to be a low bar, it's supposed to be a very low threshold, then the striking party has to give a race neutral reason for their strike. And then at that point, the burden shifts back to the objecting party to demonstrate purposeful discrimination by a preponderance of the evidence. So this was supposed to be a new way of looking at juror discrimination, to kind of stop it while it's happening, have an intervention into that moment, and give the courts an opportunity to reseat the improperly struck juror. They didn't actually explain what the remedy would be. They left that to trial judges to craft. But the idea was that this would be a stronger standard, at least than the Swain versus Alabama standard, and would kind of signal the dawn of a new era. And I know there's a couple things. I'm getting a little bit of a notification that there's something in the chat. So Debbie, if there's anything related to what we're discussing that, you know, we want to hold in, just let me know.
Okay. Yeah, I just wanted to tell people that the CLE code, hopefully we'll be able to get CLE, as I said, is KHR 3798. KHR 3798. That's it, basically. Sorry.
Sure. So this is the new standard that's announced in Batson versus Kentucky. Prima facie case, race neutral reason, and then the court determines whether or not there's purposeful discrimination. Oftentimes, well, I won't get ahead of myself. That was the standard that was announced. Do you see any potential problems with this standard right off the bat? Let me know, Debbie, if you see anything that you want to chime in on, or anyone else in the chat or the Q&A has got any
not yet, but I don't know how you can prove purposeful discrimination.
Well, there's the rub. The enforcement of Batson has really been, I would say, haunted by Justice Thurgood Marshall's concurrence in Batson, where he said that the new framework was a, quote, historic step toward eliminating the shameful practice of racial discrimination in the selection of juries, but he did not expect it to succeed. He said the decision today will not end the racial discrimination that peremptories inject into the jury selection process. That goal can be accomplished only by eliminating peremptory challenges entirely. And, you know, in his concurrence, he also kind of foreshadows modern research into implicit bias, because he expands upon the difficulties that he expects attorneys face when they exercise a peremptory challenge and don't even themselves fully have a full awareness of the basis for doing so. And so the idea that another party or a judge would have access into their motivations or intentions when some of these judgments that we make about people in front of us, strangers to us that are potential jurors, some of the judgments we make are somewhat opaque even to ourselves. Anyway, it's a very kind of prescient concurrence that I think people see as kind of a guiding light in thinking through how to improve Batson. He was really insightful into the problems that would be encountered by courts and lawyers who were faced with the task of implementing Batson. And so in announcing Batson, the court gave no guide to what sort of strikes were actually legitimate, and it became interpreted by both prosecutors and other court actors as this narrow technical rule that if anyone were to raise a Batson objection, it could be defeated just with a simple reference to a race-neutral reason. And if it even proceeded to step 2, most of the time, at least in North Carolina, where I'm most familiar with the patterns of Batson enforcement in this state, most of the time judges don't even proceed to step 2. They just find no prima facie case, don't bother with hearing the issue on the merits. But if they get to step 2, what we have seen is that almost any explanation, no matter how kind of fanciful and unreliable, will be accepted as a race-neutral reason sufficient to defeat the Batson challenge. And so the concern that Justice Marshall had that we wouldn't see a real change in patterns of race-based peremptory strikes has been borne out by studies of jury selection post-Batson. For example, the Wake Forest University Jury Sunshine Project, this study is I think, very comprehensive because it looked at all 100 counties in North Carolina, felony trials over the course of a year. And across all 100 counties, they calculated the rate of exclusion of based on peremptory strikes, and found that on average, prosecutors were excluding Black jurors at over twice the rate of their white counterparts, controlling for other factors. Some counties had higher rates, some slightly lower. You see some of the biggest counties in North Carolina pulled out there as examples. There's some other really interesting findings because this is one of the few studies that looked at kind of the interaction of factors of the judge's race, the prosecutor's race, and these numbers were consistent across lots of different contexts. But it's a study that is not unusual. We see this anytime this issue is studied, we do see that the patterns of disparate use of peremptory strikes are still very embedded in the process. And we've also seen that after Batson, what happened was not really trainings related to complying with Batson and to making jury selection based on factors other than race, but really trainings on how to evade the protections of Batson. So this is a handout from a North Carolina district attorney's training that gave some sort of, it's like a cheat sheet for step 2 of the Batson hearing of things that you can identify as a race-neutral reason. You might question, why do you need a cheat sheet of reasons why you just struck somebody if you have an actual reason of why you struck them? But this was given out as a kind of, when you're faced with the task of giving a race-neutral reason, here are some reasons you could give. This was a list of kind of a jury profile or jury criteria that a colleague of mine in post-conviction litigation got a file from a Forsyth County, that's where Winston-Salem is here, death penalty case. And it had this little note that was saying, this is post-Batson, keep men who work male jobs, all these kind of really specific stereotypes that again, we're seeing, at least in this one anecdotal example, as perfectly permissible post-Batson. And I'm not sure this is going to play, but you may be familiar with this infamous video of a district attorney training in Philadelphia that was also post-Batson, that went into great detail about how to evade the protections of Batson, and also traded in some really nasty stereotypes about the importance of excluding Black women from juries and, you know, some techniques and tips for getting around the new protections of Batson. So we can try this. I'm not super optimistic that technology is going to work, but Debbie, you just let me know how it goes, okay? This is going
There
to
were two things that I love, dancing and dogs, and I made them into a successful business.
What the fuck is it's already a card? Should it just say race? Because the thing he's actually holding up there, technically a race card, and if so, legally win the race. It turns out that's a pretty easy rule to get around. All you have to do is just come up with something other than race, just from the juror, and then do it anybody. Remember that lawyer you saw earlier? He was speaking far that ruling was handed down and was openly instructing prosecutors on how not to get caught. I think it's like the class first speaking, and then it's like the defense attorney makes the objection saying it's respecting the black rule. You're not gonna get it bad. Make something up about why I did it. I didn't think I didn't like this country. And for that one, they like to be questioned. Issues of debate. Also, the issue is the longest problem. It's long. It's pretty bizarre. It's government business. So like when they teach people to do something illegal, it's not how to get away with international issues. Well, the only thing is that he's quite enough to literally get away with murder.
You could hear that, I assume.
You could hear part of it, but at least it had the translation underneath. But I'm laughing because John Oliver also did something about judges in Philadelphia paying money in envelopes. So he loves Philadelphia.
Yeah, well, I'm sorry he keeps picking on Philadelphia, but it's really an egregious example, but not unusual. And it's, I think, useful for you all to see because, again, I'm extremely familiar with all the research in North Carolina, but this is not a Southern problem. This is really across the board, as I'm sure you're not surprised to hear. Again, Professor Elizabeth Semmel, who publishes widely on Batson, says that every study I know that has been done across this country, looking at both state courts and in federal courts, there's been a universal finding. The exercise of discriminatory peremptory strikes is a consistent feature of the jury selection system. California, North Carolina, Connecticut, Washington, Oregon, the results are the same. And even this brief filed by former state and federal prosecutors describes the discriminatory use of peremptory strikes that persists after Batson as a serious problem threatening the integrity of the American justice system. So we have Batson, we have this framework that was supposed to make this real difference in how courts address jury discrimination. But it's been almost 40 years since it was decided, and it hasn't made much of a dent in the problem. Another wrinkle to this situation that sometimes goes under-recognized is that racial exclusion is also exacerbated by removals for cause, which is the moment where attorneys attempt to exclude a juror based on some purported disqualification, so that they're biased or that it may have to do with, you know, their record, something like that. Thomas Ward Frampton, who's a professor at UVA, published an article a few years ago where he shared some research in Louisiana and Mississippi looking at the impact of prosecutors' peremptory strikes versus challenges for cause. And in both states, he found that actually removals for cause were a greater source of racial exclusion than peremptory strikes. And that's concerning for a number of reasons, one of which is that, well, this is sort of the main one. It's sort of a law-free zone. There's not really, I mean, at least for peremptory strikes, we have Batson, but the Batson framework does not apply to exclusions for cause. They're oftentimes unreviewed and seen as kind of unreviewable. We are working in North Carolina on developing tools and practice guides for attorneys to object when they believe that race is playing an improper role in a removal for cause. But it's an area of law that really needs a lot of development. Is far behind even the kind of not super effective Batson arena. So I'm going to touch briefly. How are we doing on time? 6:03.
You're good.
I'm going to touch.
And you and I have been,
Okay.
you know, going back and
Yeah.
forth. I think that's okay too.
Yeah. Great. Okay. The fair cross-section guarantee, we have Ruth Bader Ginsburg to thank for this in part. She argued Duran versus Missouri in the US Supreme Court in 1979, out of which we got this three-part framework that interprets the Sixth Amendment as providing a right to a jury comprised from a jury pool representing a fair cross-section of the community. And I'm skipping ahead because some of this is a little North Carolina specific, but the basic three-part test from Duran versus Missouri is that if you have a distinctive group, so that could be a racial group, could be gender, ethnicity, that is not fairly and reasonably represented in the jury pool, and that underrepresentation is caused by systematic exclusion, something inherent in the process, then you have a fair cross-section violation at that early stage of jury formation. That can cause such problems. When you have an underrepresented jury pool, you're certainly not going to get, the jury that is seated will never be more diverse than where you start. So you really need that pool at the beginning to be representative of the community, and the fair cross-section guarantee applies to those early stages before jury selection begins, and requires that courts create a jury pool that is representative, which is why it's so important that states like Pennsylvania have started drawing from additional source lists to try to meet that guarantee. Studies across the country that have looked at how are we doing on that front, how well do our jury pools represent the census data, the community as represented in the census data, community demographics, generally demonstrate that we're not doing so hot. And I'm working on a study in North Carolina right now. We just got the data that will allow us to answer the question of how well we're doing in North Carolina when we combine our voter and driver lists to form jury pools. We have never studied that in North Carolina after Duran versus Missouri was decided in 1979. We added drivers to our list and assumed that diversified our pools, problem solved. We're going to be in compliance with this newly developed fair cross-section right. But we've never actually had a study that demonstrates that those combined lists of drivers and voters are representative. So the fair cross-section guarantee is pretty underappreciated, under-litigated. It's very difficult to litigate. It requires a lot of discovery. And I just wanted to touch on it briefly here before kind of getting back into more of the portion of the jury formation process that happens later on when the jury is actually seated. So again, it applies to invisible stages of jury formation. If you wait to think about this issue until you see the jurors walking into the courtroom and think they don't necessarily match your impression of the community, it's too late to investigate it and preserve the issue at that point, at least as North Carolina courts interpret it. And yeah, again, I will share this PowerPoint so you can get some of these details and citations. But this is sort of the legal framework that applies to the earlier stages of jury formation. I want to back up a little bit and just touch on why it's so significant that we have diversity in our juries. Debbie mentioned some of these concerns when she was introducing the series and when she and I have talked about these issues, and I'm sure partially why you're here tonight is because you appreciate these issues, but I'm just going to share what I know about this so that we're all on the same page. Jury exclusion confers second-class citizenship, harkening back to some of the worst forms of racial oppression in this country's history. Diverse juries return less biased verdicts and generally perform better across a number of rubrics, including accuracy. They make fewer errors, consider more of the evidence, are more likely to discuss uncomfortable or sensitive topics, spend more time deliberating. Generally, all of the qualities we'd like to see in jury deliberation, we see more of that when a jury is diverse than we do when a jury is homogeneous. And it turns out when we survey both jurors themselves and members of the public that confidence in the legal system is really tied to jury diversity. So if you have an all-white jury, and you survey members of those juries, what we've seen is that they don't really consider themselves to be legitimate, nor do those that are aware of the composition of the jury. So it's really closely tied to faith, public trust, and confidence in the legal system, the extent to which we're able to actually seat and achieve jury diversity. And as we saw the court recognize in Batson versus Kentucky, when this right is violated to have a jury composed without discrimination, we see the rights of the defendant violated as well as the juror, and the harm is inflicted on the whole community because it's really kind of a harm that touches on the integrity and reliability of the justice system. Some of the research that we've seen into perceptions of juries based on their composition demonstrate that even when you have the same outcome, when you have a racially mixed jury, any outcome is seen as fair. But when you have an all-white jury that comes to the same conclusion, their convictions are seen as less fair. And also the outcomes themselves can be different based on the composition of the jury. A 2022 study published by a colleague of mine here at Duke, as well as some other co-authors, demonstrate that a racially mixed jury decreases the likelihood of conviction and decreases the likelihood of receiving a life sentence. So both in terms of conviction and sentence, the composition of the jury impacts outcomes. One of the studies that I find most astonishing, and then I also hear judges in North Carolina tell me that they see the kind of conclusions of this study playing out in their courtroom all the time, is that even just having one or a very small number of people of color in the jury pool can impact outcomes. So this study found that when you had just one Black person in the jury pool, conviction rates between white and Black defendants were nearly identical. But when you had all white jury pools, you saw disparities in conviction rates. So it shows how even a small difference in jury composition can make a significant difference in jury outcomes. The Equal Justice Initiative has observed that the sting of mistreatment for those who are subjected to jury discrimination can linger for years. And I think this is something that we haven't done a great job studying. It's something we're trying to build up the ability, the capacity to do more research into here at Duke through this Struck Jurors project that was started a few years back, interviewing people who were struck from juries. But we know enough anecdotally to know that this can be a deeply painful and humiliating experience for the jurors themselves. This is Dorian Hamilton. She was struck from a Wake County jury in Raleigh a few years back and speaks really powerfully and eloquently about how she was very disappointed that the opportunity for her to serve on a jury was taken away. And she felt naive thinking that she would be allowed onto the jury. She moved down to North Carolina from New York. And where she had lived in New York, it was pretty, she was one of the few Black people in her community. And she said that in North Carolina, she saw that there were Black judges, Black lawyers, and she thought that there may be more racial justice, and maybe that she would be welcomed on a jury here, and that things here might be a little bit more fair because of the number of Black lawyers and judges in the justice system. And then she was struck. She had no, there was no obvious reason to her why she was struck. There was a Batson challenge that was raised about her strike, and the whole thing was deeply upsetting to her, as captured in this piece that was written by Jacob Bebo called Race Neutral, about this problem of jury discrimination. The Struck Jurors Project here in Durham interviewed a potential juror in Durham County named Jermichael Smith. And his story is particularly compelling, I think, because he talks about how difficult it was for him to get to court for jury duty, and how he got the summons and he really didn't want to go. Like so many people, he just thought, this is a nuisance. I have, my job, my life, and this is interfering with my plans. But he made the effort. He got down to the courthouse, and he did what it took to get himself there and to make himself available for jury service. And then he watched in a case involving a young Black male defendant, and it was an interracial crime of violence. He watched as multiple Black jury panelists were struck, and suddenly he was motivated to stay. He really wanted to be seated on this jury. And he said, quote, "When you see that the defendant is going to get stuck being judged by middle-aged white women, middle-aged white men, as a Black man, I didn't feel like it kind of hurt me that I didn't get picked." And he went on to explain that if he receives a jury summons in the future, he's going to think twice about going down to the courthouse, because his experience didn't show him that he was wanted or welcome there. We don't have enough research for me to really show you numbers about the impact on potential jurors, the impact of juror discrimination on potential jurors. But we know enough to know that it is harmful, that it distorts outcomes, and that it's of great concern. It's a strange right that belongs to the juror but is raised by the defendant. So it's with the exception of a couple class action lawsuits filed by struck jurors, for the most part, we don't hear jurors' voices. And I think this is an important part of this story that I always want to take a moment to focus on and think about.
So is that what your Struck Jurors Project deals with, is trying to track down jurors who have been struck in North Carolina?
It is, and I don't want to take credit for starting it. It started at a local nonprofit a few years back, and so I have all of the kind of interviews, photographs, and stories from their initial project. I'm working on getting IRB approval to get it going here at Duke, and kind of get it started again. And we would start with folks who have been, especially in the very few cases that we now have where Batson objections have been, where courts have found a Batson violation on appeal. We intend to kind of talk to those jurors about their experience, and also just create opportunities for panel discussions and other learning opportunities, public education opportunities, where these folks can kind of share their stories and their voices. But it's been on hold for a couple of years as we've been, kind of focusing on other more data-driven research projects. But yeah, the Struck Jurors Project is something that we are hoping that we will have some 2Ls and 3Ls pick up this fall. So stay tuned on that one. These are some of the things that jurors in Durham County, I'm not sure that the text is showing up that well, have said. These were all said by Black potential jurors in Durham County before they were struck. And so this is from a project that was kind of capturing both through removals for cause and peremptory strikes, the way in which, when Black potential jurors explain the way that they or people in their community have been treated by the criminal justice system and are removed on that basis, what that does to to our jury pools and to our seated juries. And I think that is captured by this quote. This is Justice Liu writing for, I believe, the majority in People versus Triplett out of California. To many people, excluding qualified Black jurors based on their negative experiences with law enforcement or the justice system must seem like adding insult to injury. It's time to reassess whether the law should permit the real life experiences of our Black citizens to be devalued in this way. At stake is nothing less than public confidence in the fairness of our system of justice. So in addition to harming jurors, this is James Kirkland Batson again, at home with his family. We know it harms defendants. We know that the risks of wrongful conviction and just the confidence that you're being judged by a jury of your peers is really undermined when we have these patterns of exclusion from our jury pools. Also, we have cases where we see highlighted the way in which, as an interrogation tactic, the racial exclusion from juries is taken advantage of to coerce confessions. So this is a case from Illinois where a detective said, "Gotta love that word, jury of your peers, because when you look over, you're not going to see one person that looks like you or acts like you. So we've got a jury not of your peers that's going to judge you." And this was in an interrogation where law enforcement was trying to, encourage, coerce, somewhere on that line, a confession from a suspect. And, when we talked about that disappearing exercise of the right to a jury trial, this is an example of how it can show up in dissuading people from thinking that they really have a fair shake when they go in front of a jury. So when we have patterns of exclusion and the disparate striking of African-American jurors and other jurors of color in particular, it can show up in these moments where people are coerced to confess because they are being told that this right that is enshrined in the Constitution is actually imaginary rather than real. And so, kind of in summary, when the jury formation process is perceived as unfair, it undermines the public legitimacy and the public trust in the prosecutorial function. It may chill future participation in the justice system by marginalized groups. Cynicism about the legal process is also correlated with the failure to follow and respect the law, and it undermines the democratic check on the state's power. Let's see. We have only about 9 minutes left, so I'm just going to quickly kind of try to skip through these slides where the Batson framework has expanded to include strikes that are based on gender or ethnicity, strikes of juror panelists who don't share an identity category with the defendant who's raising the objection. So over time, the Supreme Court has kind of expanded Batson or clarified that it extends to more than just the context that was present in James Kirkland Batson's case. And we see over time that the court has kind of continually talked about Batson in these really kind of muscular terms, as though it's this very strong standard that protects against juror discrimination. And anytime we have these really egregious cases reach the Supreme Court, the court speaks in very strong language about how protective Batson is. But there's a disconnect between that language and between the actual enforcement of Batson in courts across the country. These cases, unfortunately, I think are anomalies rather than representative. In North Carolina, as Debbie was mentioning before I began speaking, it took from 1986 to 2022 and over 100 Batson cases on appeal before our courts ever found an instance of discrimination against a juror of color, despite numerous cases putting on evidence demonstrating that this was a problem, and studies showing that this trend was persistent even post Batson. So these are some of the US Supreme Court justices who have written these, written for the majority in these cases that speak about the Batson standard in very muscular terms. But states are still finding, because it doesn't reach implicit bias, because it requires demonstration of purposeful discrimination, that Batson has proved insufficient. And so what we're seeing is this trend to replace the Batson framework with something that is broader, that does not require a demonstration of purposeful discrimination, but also extends to strikes motivated by implicit or unconscious bias. These reforms, and some of this has been through the evolution of case law, like in Florida and Missouri, have done away with step one of the Batson framework. So you no longer need to put on a prima facie case, you go straight to the merits. And then when you get to the merits, the question is not, can you show intent, but would an objective observer looking at these facts think that there was reason to believe that, based on a preponderance of the evidence, that this strike was motivated or could have. It depends on the state. Some say would have, could have. There's different kind of levels of stringency in the standards that have been announced by these states that have replaced Batson. But what's common throughout is this intention of coming up with a standard that actually is up to the task of policing juror discrimination. We also, I would say that the reform movement has stalled a bit from its kind of exciting, right out the gate heyday of 2018 when Washington adopted GR 37 through maybe 2022. But there's still committees and courts in Colorado, Utah, and Michigan considering adopting similar reforms. And Arizona, as you may know, abolished peremptory strikes altogether in 2022. Just a few months ago, we saw the first published account of the impact of abolishing peremptory strikes in Arizona, which demonstrates that in Maricopa County, which is about 65% of the population of Arizona, there's been an increase in the representation of underrepresented minority groups since the elimination of peremptory strikes.
So it's so interesting that, so Maricopa County also recently increased the amount of pay to jurors to, I want to say $150 a day, I think it is, which, you know, and Maricopa County, like they have, they allow cameras in the courtroom. I mean, Arizona is I'm going to say progressive, as far in terms of the legal system. They now, are using chatbots to help explain judicial decisions. So are they the only state that has abolished peremptory strikes so far?
They are the only state. Canada recently abolished peremptory strikes in 2019. England didn't use peremptory strikes for much of its history, but in the few areas where they were still using them, they got rid of all of those in the 80s. So they're the only state. I would say some of these states where jury reform movements are still active, it's very much on the table that could be one of the directions that they go in. But Arizona so far is the only state in the United States that has abolished peremptory strikes altogether. And, you know, everybody who's interested in this topic wants to know, what have we learned so far in these states, in Arizona and these other states that have tried to strengthen or replace the Batson standard? And I was very excited when this publication came out, because for the most part, I would say it's too soon to say. And the problem of failing to collect juror demographic data means we don't have a baseline for comparison in these states, because we just don't know what was happening with removals of people of color or just demographic data writ large in these states before the reforms took effect. So it's difficult, but Washington and California in particular, I'm familiar with the appellate treatment of GR 37 in Washington and AB 3070 in California. And I would say what I can see from the cases that have gone up on appeal is that people are raising more of these objections. They're getting sustained more often. Prosecutors are using them as well as defense attorneys. So we're starting to get a body of case law out of those states showing how including implicit bias, getting rid of step one, and some of these other changes that they have implemented, the objective observer standard and whatnot, have really made an impact. But it's very early in this movement. And it's, you know, we'll learn a lot. And you're right that Arizona is on the forefront of a lot of experimentation and reform across the board when it comes to jury issues. I know we're right on our last few minutes, so I will leave you with my slides on tools for addressing bias in the courtroom, and some of the policy reform recommendations that we've made here in North Carolina and that other groups have made. If it's okay with you, Debbie, I'd love to share my PowerPoint with you and you can distribute it.
Yeah, that would be great. And I can distribute it to the attendees. This was phenomenal. Thank you so very much for joining us, for enlightening us, for educating us, informing us. This truly was very special, and I hope everybody enjoyed this. And there's maybe a Q&A, and hold on, there's a, yes, just a thank you from the audience. Thank you, Kathy from League of Women Voters. And I just want to, you know, we may be back to you. I have great hope for Pennsylvania. But of course, as I say, we are usually not on the forefront of being an innovator, but I have great hope. So I actually went to Harrisburg today to talk with a representative about jury service. And, you know, I think it's something that we really all need to focus on to reinvigorate and reinstill confidence in our judicial system. So thank you.
Well, I wholeheartedly agree. And I think that groups like this are critical to that endeavor. And I really commend you for all the work that you're doing to highlight this issue and to move these conversations forward. And it's an honor to be with you. So thank you so much for inviting me.
Okay, everybody, thank you for joining us and have a great evening. Bye.